Okay, I think we're ready to get started. Hi, everyone. My name is Autumn Fitch. I work in the development department for Pine Tree Legal. I'm also a member of the Passamaquoddy tribe from Indian Township. Today, I have the great honor of coordinating this conversation. I'm joined by a panel of experts who are all advocates within the Wabanaki community. Native American heritage is unique and sacred. It's still alive today and has been becoming more visible within American society. But there are many legal issues faced by Native Americans that are still not visible. We really appreciate you joining us today in recognition of Native American Heritage Month to hear from our experts on current issues. I'll let our panelists introduce themselves. Vice Chief Daryl Newell, could you please introduce yourself?
Well, I'm sorry. I talk a lot, but I don't say anything. I'm Vice Chief Newell of the Passamaquoddy tribe at Indian Township, and it's an honor to be here on behalf of our people with the Pine Tree Legal Assistance. I just want to start out by saying that Ryan Lolar and Lisa Chase have been a force to be reckoned with among our Wabanaki Intertribal Repatriation Committee efforts. And we've done a lot of good work. I refer to them as our big guns, and they've proven to be so. So anyway, thank you.
Thank you, Vice Chief. Roger, could you go ahead and introduce yourself?
Dungog Tidawen, Lewis Nil Roger Paul, Linamik was not il Madakmigog, Daluda Giluo. I said hi. In our language, a lot of our language today is still being used. A lot of you speak our language too. I'm Roger Paul. I teach language at the universities and at Indian Island Elementary School, and so I am honored to be invited to such a panel. And it's like Chief Newell said, the big guns with Ryan and with Lisa, and actually with the whole group there at Pine Tree Legal. It's an honor to be even invited to be a part of this, and I'll do whatever I can to try to answer any questions that you guys have. I don't have many legal answers, but if you got language questions, I can answer that. Chiwaliwan.
Ryan, could you please introduce yourself?
Yeah, hi, I'm Ryan Wogar. I'm the NAU or Native American Unit Advocate here at Pine Tree Legal Assistance. I work out of the Bangor office, but we provide coverage across the state to Wabanaki members and other members of federally recognized tribes.
Thank you. So we're going to begin on our topics. If you do have questions pertaining to the topic being spoken of, go ahead and put that question in the chat. We have someone from Pine Tree Legal screening the questions, and we'll have time at the end of each topic to take some questions. So Ryan, will you start us off by giving us an intro into Indian law?
Yeah, of course. So first of all, I'd like to huge thanks to all the attendees, to you, Autumn, and Nicole, who helped set this up. Of course, to Vice Chief Newell and Roger for joining us. It's an honor to be on with all of you. So I think first I'll sort of introduce the NAU and what we do here. If you know about Pine Tree, we are a nonprofit here in Maine that provides legal services to low-income people, and a variety of other services where we can. The NAU specifically provides legal services to low-income tribal members of the Wabanaki tribes or of any federally recognized tribe that lives within Maine. We provide a lot of the same services that Pine Tree broadly itself provides. So housing, public benefits, family law, whether that's protection orders, parental rights and responsibilities, divorce, education issues, consumer issues like debt and student loans and things of that nature. and of course the NAU, we have the more particular focus in who our clients are. And one difference too between the clients that the NAU has and the general sort of pine tree operation is that, as Vice Chief Newell kind of hinted at, some of what the unit does is also work more broadly with the tribal governments and with intertribal organizations on systemic projects to really tackle some broad issues. We also can take cases within the tribal courts, and part of what that allows us to do is in a limited setting, do limited representation in the Penobscot Nation Tribal Court and in the two Passamaquoddy tribal courts. So that's just a little bit about what we do at the NAU. If you ever need to get in contact with us, I'd really recommend checking out our awesome website. It's ptla.org. There's a lot of good resources on there. And even if you have an issue or someone that you are working with as an issue that we can't work with, then at least there are a lot of really great resources that you can either be directed to or that we provide right on there. And with that general overview of who we are, who I am, and what I kind of do, I'll sort of get into laying the groundwork on Indian law and sort of set up the rest of this conversation, hopefully. So first, I just want to address, so there's about 574 federally recognized tribes in the US. There are a number of state recognized tribes, and there are other tribes that are either state recognized or not recognized at all that are still seeking recognition, which is a complicated process. It's important to note about all of these different tribal communities that they might have crossover culturally or historically, but each tribal government is a distinct entity. And different tribes and different groups of tribes in different places can have distinct histories, cultures, et cetera. I think the broader culture, there's a lot of a formation of, a so-called, pan-Indian identity. And I think in Indian country, there's been a positive aspect of that where a lot of, indigenous people have sought each other out to be able to advocate for new laws and to advocate for restoration of sovereignty and land back and other important issues. But I think there's also been a negative in the broader, non-Indigenous culture, pan-Indian identity formed. And that's where you see a lot of stereotypes and a lot of misunderstandings about what tribes are, what tribal governments are, and what Indigenous people, how Indigenous people are. And so with that sort of background, I think it's really important to start that the foundation of federal Indian law and the foundation of Indian law, even here in Maine, where we have a relatively unique situation, is that tribes and Indigenous people's right to self-government is inherent. It doesn't come from any external source. It comes from the tribes and from Indigenous peoples themselves. I think people know about the US Constitution and state constitutions and a lot of laws and government documents like that. Those don't really ultimately grant or give any powers, authority, or right to governance to tribes. It really comes from the tribes and the people of the tribes themselves. And that includes all functions of government, in relation to what the NAU does. And if there are any attorneys or advocates on the call who work in administrative or legal settings, I think it's important to note that includes tribal courts and tribal agencies. So when you deal with a tribal court or a tribal agency, that tribal court or tribal agency is, it's part of that tribal government. You're operating with an entirely different system than the federal or the state. And when you're looking to how best to operate in that system, you should look to what that tribe's rules are, its regulations, its laws, its culture, and its history to better understand how to operate there. Because I think sometimes people can get kind of confused and they wonder, because of some things they've heard or the Settlement Act or things they've read, that they need to look to this or that at the state level. And I think really you should focus on, if you ever do work with the tribal communities, looking at what the tribes are doing themselves. That's just kind of a foundation for getting more into talking about Indian law at the federal level. Again, tribes predate the Constitution. The right to self-governance is inherent But the Constitution does set a baseline for how the federal government itself has to interact with tribes and with indigenous people. So the two big parts of this are the Indian Commerce Clause. If we have any legally minded people or historians on the call, you might be aware of the Commerce Clause generally. But if you read it, it says that Congress has the authority to regulate commerce between the states, foreign nations, and Indian tribes. So there's a recognition in the Constitution and that provision of tribes as their own entity that have their own sovereignty. There's also, and this has been changed over time, but there's language in there about Indians not taxed. That's in the federal Constitution and in the state constitution and in a lot of state constitutions. That's a parceling out of indigenous people from the broader federal US citizenship context. And as much as there is a complicated history there, and that has at times led to negative consequences, at the same time, it's also important to recognize that it means that the US federal government has from the start acknowledged and recognized, at least in part, the inherent sovereignty of tribes, which is incredibly important. A couple other important things to know from federal Indian law, and then we can sort of hop over to Maine really quick and see why it's different. The big one is this trio of cases that happened in the Marshall Court. So the Supreme Court of the United States, the so-called highest court in the land. Justice John Marshall sort of penned a lot of these decisions and influenced them. But there was these three cases, McIntosh v. Johnson, which you might know if you're taking a property law class. And the other two were Cherokee Nation v. Georgia and Worcester v. Georgia, which might be something that's within the realm of people's knowledge, even if you've just taken a history class. But I think, they're not often taught quite in the Indian law context, because a lot of, especially public school and I think non-Indigenous history settings, we don't really talk a lot about Indigenous history. But those three decisions came out with three really important principles to think about, or recognize three really important principles that, again, they have complicated roots that I wish I had time to get into, but I don't. But the first of those is really this concept called the discovery doctrine. And it's this really horrible thing if you look back at the history of it. But what it does in part for tribes and tribal governments today is it was this recognition that the US government was the entity that had to enter into relationships with tribes. And it in part recognizes the right of tribes to occupy lands. So basically, the discovery doctrine says that all these former prior colonial powers to the United States inherited some right to, essentially be colonial, to participate in what were a lot of times the worst parts of colonialism, and that the US basically got to continue on with that system from there on. But again, the right of tribes to occupy their lands and the recognition of tribal entities as distinct from and not completely under the umbrella of the US federal government is also there. Another thing that happens, again, is that recognition of tribal sovereignty. So the Supreme Court recognized, it even validates in some of these cases, that tribes have the right to self-govern, and at least as it deals with their own membership, have the right to dictate what goes on with their members and the right to dictate what goes on within tribal lands. And finally, the trust responsibility. The trust responsibility is another really complicated thing. We can think of it as in a positive way in the modern context, because it allows for a lot of support for certain tribal programs, but I think it really goes back to this very paternalistic root, and that's where it comes from in these cases. And you can see a Maine equivalent if you look up Murch v. Tomer, which was the Maine case where they essentially established the similar finding here. But basically, the US federal government at the time and Maine in Murch v. Tomer take it upon themselves to say that they have some right to weigh in on how tribes can self-govern because of some inherent flawed quality that the federal government and the states at the time, and you could argue, listening to some people talk now, maybe now, that they find with indigenous peoples and with tribal governments. So it's a complicated route. It is changed a little bit. The final thing I'll kind of cover is for the federal relationship is that fast forwarding, there's this case US v. Kagama. And in that case, the Supreme Court of the United States holds that because of the Indian Commerce Clause and some of the language in the Constitution, because of some early acts and looking at other parts of the history, that the United States federal government has what's called plenary power, or in other words, absolute power, to make determinations over tribal nations. So that's what empowers the federal government to pass laws that impact Indian country, and to do that over the objection of, for instance, states, and a lot of times, to be frank, over the objection of what tribes want themselves. So a lot of times that is part of it. And so this was very bad for a while. In fact, there was this era called the Termination Era, not to mention some other really terrible times earlier on, but the Termination Era saw the US federal government completely turn some tribal governments into corporations. But as that went on, in the 1970s, the plenary power was used for good in some sense, or at least was used to correct some of those prior ills, prior poor choices. And the self-determination era saw a lot of important laws that, protect Indian children today. So the Indian Child Welfare Act, for instance. It also saw the setup of a federal support for tribal education, for tribal healthcare, for tribal other tribal programs in the Indian Self-Determination and Education Assistance Act. So, it did sort of transition there more broadly over time. I think largely it is still rooted in paternalism, and there's a lot of room to grow for the United States and for the states to figure out how to be better partners in the government to government relationship. But so quickly to turn to Maine so we can get to what our other great panelists have to say. Maine is in a very unique position because the colony of and then state of Massachusetts made a lot of agreements with the Wabanaki tribes over time. And Maine inherited that relationship in the Maine Constitution in a provision that was for many years until very recently prohibited from being printed. And that provision that Maine didn't want to be printed basically said, hey, Maine, you have all these obligations and trust responsibility to the tribes that you need to live up to. And I think, I can't speak for what the actors who made choices did, but I would assume that they really didn't want to live up to those obligations. And so that's probably why it went out of print. But there are these laws that are passed in the 1790s and the early 1800s by the US federal government, as well as that Indian Commerce Clause. But the laws in the 1790s and early 1800s are called the Non-Intercourse Acts. They basically say, they double down on this principle that's reinforced in McIntosh v. Johnson and reinforced in other precedent that says the federal government is the one that has to interact with tribes. States can't, territories can't. It needs to be, individual people can't. It needs to be the federal government. And so, and I think one part I'd like to really highlight about this is this leads up to this case, Joint Tribal Council of the Passamaquoddy Tribe v. Morton. And one thing that gets left behind a lot of times in this case that I learned about a few years ago was there's a lot of Passamaquoddy people, specifically, I think elder women, that really fought to, people were trying to come on to Passamaquoddy land and, with a bulldozer, and there were women that, sat in and stopped that from happening. And so there's a lot of, whenever you see political stuff or legal stuff, there's a lot of times there's activism that happens beforehand and really paves the way. And that was true of this case. But this case basically said, look, Massachusetts, look, Maine, you made all these deals, but you shouldn't have. And it was illegal for you to do so because there was this law and all these constitutional provisions that said that you were the wrong party to be making those deals. And so you hear the very famous that 2/3 of the title of Maine was in dispute, and Maine was very worried about this, and people were very worried about this. But that really sets the table for leading to the Maine Indian Claims Settlement Act and the Maine Implementing Acts. But in the meantime, there was federal recognition for the Penobscot Nation Passamaquoddy tribe who had full access to all of those great laws that I was talking about above, without any particular restrictions, because Maine's deals were all invalid at that point, on that federal recognition. So there was a lot of, I would say, there was a lot of great stuff to be done. And I do see a question there. The Joint Tribes v. Morton case was in 1975 in the First Circuit. But that case opened up the potential for further litigation. It brings Maine to the table to do the Settlement Act. I, probably can't really comment too much on the Settlement Act, but I will share some great references. There was a recent lecture given at the University of Maine School of Law, the first annual Indian Law lecture, which had great information. There's a series of lectures given to the Maine State Legislature not too long ago that are on Sunlight Media Collective that are really great. On WERU, Donna Loring hosts something called Wabanaki Windows. There were some great ones she did, Unpacking Sovereignty, with Professor Errol Prinz and Professor Darren Ranko, who's Penobscot, that are really great. The Maine Indian Tribal State Commission has great resources on the history of this. And I will say there's been a lot of, too many to name probably, events, but events that have been, I think, hosted mainly by Molly and Dana, who's the Penobscot ambassador, and Passamaquoddy citizen and attorney, Michael Corey Hinton, that they've hosted a lot of really great talks on sovereignty and the history of the Settlement Act. I think I'll kind of hurry through this last section here. The most important thing to note, the biggest myth that you will ever hear about the Settlement Act, is that it gave anything to the tribes. As I sort of discussed before, tribes don't have their right to self-governance, their right to sovereignty, the right to lands, the right to natural resources, the right to make cultural determinations, to enforce laws, to make laws, is inherent. It doesn't come from anything else. Really, the only way to look at the Settlement Act and the Implementing Act is as limiting that sovereignty. It doesn't really give or grant anything more than it sets parameters and sort of boxes it in to an extent. Specifically, it limits the criminal jurisdiction of the Wabanaki tribes, limits their civil jurisdiction, and particularly there's a provision in there about them being like municipalities. I think Mitzik had a report done on that covers how some of these provisions got in there. I really, would encourage people to read that report that Mitzik got done. It's really great work that I think the people at Suffolk University Law School did. And then the final thing it does is it really limits the ability of the federal government to effectively accomplish its part of the government-to-government relationship with tribes. And it does that by limiting the applicability of federal law, both through saying that state law applies in so many sections of the act, but also it says in a provision that any federal law that is passed after 1980 that affects or preempts Maine law and that does not specifically state that it's applicable in Maine does not apply in Maine. And I think that has really restricted the applicability of a number of pieces of federal legislation that have been passed that would really benefit and improve the situation for a lot of tribal members and for the tribal governments. And I think that these provisions are uniquely limiting in a lot of sense. And so that's sort of it for me. Is one final thing. I think I'm going to follow up with some of the resources I've named to our development team, and hopefully those can get sent out to people that registered for this afterwards. So I hope this has been a somewhat helpful overview, and hopefully, I think the best thing is to always continue to educate yourself on these issues. And so look up some of these other resources afterwards. And thank you so much.
Thank you, Ryan. That was a lot of great information and resources. We're going to move on to Vice Chief Newell. Could you please speak to us about the current efforts towards tribal sovereignty restoration?
Yes, thank you. Tribal sovereignty restoration has been in the forefront of my personal efforts and my efforts as Vice Chief of the Passamaquoddy tribe for the past few years. I'm old enough to remember wards of the state status and that era of time where we were at a disadvantage, and I think Governor Mills in particular is kind of still stuck in that mode. Her preference is to deal with tribes as an inferior, and her mode is to control tribes and to dictate to the tribes on how to conduct themselves. And tribal sovereignty restoration is just that. I mean, we were sovereign from the mid 70s when we were federally recognized until 1980 when we settled. And what we intended to assert was a claim to land to more than 2/3 of the state of Maine. And my opinion 40 years later is that we should have resolved that issue. We should have resolved a claim to land, and we should have done that mutually. There should never have been any discussion about sovereignty, whether it be compromised by the tribes or conspired to be stolen by the state of the tribe's sovereignty. That issue should never have been on the table. And we did have representation. We had advice and direction from good people, but we were also under duress. We were threatened by the new administration, federal-wise, where we were pressured to make some sort of a compromise and settlement. And I don't imply that all of our settlement is based on compromise. It's based on a conspiracy to take the sovereignty away from the Maine tribes. And our efforts recently have been kind of several avenues of effort to restore tribal sovereignty. And to me, bits and piece limited sovereignty is not sovereignty. Sovereignty, Ryan had mentioned that it's a government to government relationship, but it's not only that, it's an equal government to government relationship where tribes can make decisions for their people with without outside interference, or at least with restricted outside interference. It's a challenge to restore that. And we come across resistance from the state and from the executive branch in particular. I mean, it's difficult to talk about state Indian policy, state Indian relations with, and I try to generalize, and it's difficult to do that because we have allies among legislators, the state leadership. We have friends. We have people that are wanting to support our efforts in restoring sovereignty. So when I speak about the state, I try to qualify my statement so that I don't overlook our good relations with people out there that know the importance of tribal sovereignty. It doesn't just benefit the tribes; it also benefits the state of Maine if we were to able to be to restore our tribal sovereignty. So, thank you.
So we do have one question in the comments. If you want to respond to that, Vice Chief, as Solomon wrote, I know that the doesn't apply to Maine unless explicit. Part of the federal statute was not added until the last moment. Do you know why it was added or who wanted it?
Well, over the past 40 years or so, excuse me, that's been the greatest insult for me personally, is to specifically exclude our tribes here in Maine from any federal Indian law passed after 1980. It's a deep cut to to who we are as Native people. And you know, again, there's conspiracy, there's strategies that were implemented by the state, by state representation, the Attorney General office, and yeah, it's an injustice. And Ryan again mentioned that the settlement didn't give Maine tribes special status. The settlement gave the state of Maine special status. There, in terms of tribal state relations, there's no other state in the country in the position of the state like the state of Maine. We're just at a constant conflict over tribal state relations, and I guess that's my response.
Thank you for that insight. We're going to go to Roger. Roger, could you tell us about your work with Wabanaki language?
Yeah, I've been a speaker all my life, and I learned English at the age of 6. And Sister Jean Marie made me speak English, and so I learned. But as I went up through my younger years, I went off to become all these other things and wanted to be an astronaut like most people my age, and realized that the biggest problem I see with me fitting into the dominant American culture is that we're not considered equals. And so I, as belligerent as I was, continued on anyhow, and realized that there's what Ryan and the Vice Chief were mentioning, such a misunderstanding of who Indigenous people really are. And not only John Wayne is to blame for this. I mean, a lot of, I'm partly to blame. I work for an educational institution who makes sure that this is taught that way, that dominant American culture is a paternalistic way of life compared to Indigenous peoples. So that's when I learned that from my language, I could see a worldview that was actually very inclusive. And learning English and living out in the dominant American culture world, I learned how the English language is not that way. It's very noun based, and it's person, place, or thing, and it's very labeling and separating. Whereas our language is more, a lot of people say verb oriented. I want to say verb phrase oriented. We describe what's around us, and we describe the relationship we have with everything around us, and that's the basis for our language. So whenever you're dealing with Indigenous peoples in any legal sense, you have to keep that in mind, that Indigenous peoples in their language do not see the world as a person, place, or thing. They don't see the world as something that is objectified. We describe everything in our language from what our relationship is and what we see. And everything is related. Along those legal, tying into some of the legal things that were said, like the Land Claims Settlement and the Implementing Act, those were not supposed to be Indian policy. They were simply supposed to be land acquisition or land settlements. And they squeezed in that, oh, this is now Indian policy for Maine Indians. No, a lot of that language that was put in there, you can guess, and now I'm no expert, but you can guess was not put in by the tribes. A lot of those language that was put in, and from a story that was told to me by one of the actual people who negotiated. And he told me that, he said, when they negotiated and they were put under duress, both sides stood to lose. They settled out of court and went through quickly everything to be determined later. And that's where the tribal Mitsic came about, to determine this at a later date. And this is where they had the upper hand, where they said, good, the legislature actually had to approve all of those things that were unsettled. There's still things unsettled in the, I don't know, what is it, 40 plus years it's been there. They have agreed on one thing. They got a video done. And I think that's it. And it's not because Mitsic is not doing good work. It's because once they come up with a recommendation, it's shot down by the legislature. And it was planned that way. I agree with the two speakers earlier. But anytime you deal with legal, anytime you deal with sovereignty, anytime you deal with everything, with tribes, language matters, worldview matters. Our language describes the world around us the way the ancestors did. So by using the words of our ancestors to describe something, we're seeing the world through the eyes of our ancestors, the way they saw it, and the way that we're not separate from the environment. We are the environment. Our stories tell us we're part of the environment. Our stories tell us we're the problems in the environment. We're kind of like the stepchildren that don't listen, the humans. The environment will do fine without humans. But I got to tell you, we, in our language, when we use the words that we do, it describes what we see. For instance, one word would be dupquan, which is one of my favorite words, dupquan. And from Sister Jean Marie, when she used the word dirt, which to us is soil, dupquan, she would use that to vilify things. Oh, that's a dirty thing to do, or that was a dirty trick. Oh, that's a dirty thing to do. Don't do that. And it was something that she said that you don't want on you. You wipe it off you, the dirt. Now, in our language, dupquan, or soil, is a compound word, and it's actually, our language is very polysynthetic like that, and we have morphemes from other words that come together to form these polysynthetic words. So dupquan comes from dupe, something that's full, and quan, a substance that's essential, like samagwan, dupquan, and other things like that. So dupquan, I asked, yeah, abachimazam guznek, happen Kevin, why do you say dupquan? What does it mean? And he said, well, it's a substance full of life. And I said, what do you mean by life? When you pick up a handful of soil, you're picking up molecules of our ancestors who have decomposed. You're also picking up the nutrients of their bodies that have gone back into the soil to create more nutrients for plants to grow, for animals to eat from those plants, for humans to eat from those animals, and to keep that cycle going. Every bit of that soil gives new life. And he said, that's why we call her our mother. All of those nutrients that come from her is what keeps life going for all creation. Gatapu, skijinu, gatapu, not just humans, not just Indians, all of life is from her. She gives us everything we need except for sunlight to be able to live. And that's why we look to her as our mother. And that's the way we start seeing our worldview. And it goes from there, and it stays in that concept. From the dominant American culture perspective, that there didn't seem to be that connection. Dirt to them was something evil, whereas dirt to us was something essential, was part of our life, was part of who our ancestry was. And that kind of illustrates just how separate things are. Whenever you're dealing with a native client, be very careful about the way that you explain things in English, because they don't understand it the same way that you would think you're explaining. You can explain all these great things, and it's pretty simple to you. But from a native perspective, who looks at the world from a completely different worldview, that may not mean the same thing. Family is another example. When they say, oh, well, this is from your family. Family to us doesn't necessarily mean human. Family to us definitely doesn't mean biologically related, close. And everything about our community is family. Wait, I said that backwards. About everything about our family is community. There we go. I'm still learning English, though. I'm doing good. But the thing is, consider whenever you're working with a client, or whenever you have any legal dealings with Indigenous peoples, try to remain open. They don't see the world the same way that dominant American culture does. We're not all about all of what dominant American culture wants. Wealth, power, and influence is not forefront on our minds. Well, not all of our minds. There are assimilated people in every culture, But keep in mind, when you think of our people and our language and the way that we live and the way that we try to maintain our sovereignty, we're trying to maintain who we are and that language just reinforces who we are. That language reinforces our worldview. And our worldview doesn't always fit neatly into a constitution or any sort of a legal document. We have to remember that. So whenever we're dealing with legal documents, or whether we're dealing with governments from other language backgrounds, the meanings don't always mean the same. I better stop there and open up for some questions. Chiwiliwin.
Thank you, Roger. That was really deep and meaningful as it pertains to law, Indian law in Maine. We're gonna go to some panel questions now. Vice Chief, are there any specific practices or traditions from the Passamaquoddy tribe's traditional heritage that is still a part of your daily life?
Well, I claim to be a spiritual man. I'm an elder here in our community. I carry a sacred pipe that I earned through fasting, and I practice Indian ways to the best I've learned how. And there's some level of restoration there as well. We've never been disconnected in our ways. It may not have been clearly visible to us, but it remains there. It's just as strong as it was from the very beginning. And I pray Indian way. I speak our language as well, and I speak fluently, and that's how I pray. I pray in our language, and I smudge and light the pipe, and I offer that to the people, and those people. And I have a telehealth conference. My phone's ringing, so I have to leave you. I apologize. Thank you.
Okay, thank you so much.
Autumn, can I jump in where Vice Chief left off? I see he had to pull away, and
Yes, of course. Thank
I
you.
just want to clarify something like language. I want to interject some language identity into what he said when he said that he prays Indian way. Now, pray has gone through many evolutions as of a definition over the years. When Wabanaki people pray, and it's daily. I mean, we just had a holy day called Thanksgiving that they've made a national holy day, and it's good. It's never a bad thing to give thanks. It's good that they give thanks once a year for Wabanaki people, and I can count myself in that. Every morning we get up, we give thanks, we offer food to the ancestors. We smudge and cleanse ourselves and go through the ceremony, and we give thanks. Now, when we say pray, we pray by giving thanks. We don't ask. Well, I have been guilty of asking for the Red Sox to win time to time. That doesn't always work, but that's not our definition of pray. When we say imi, it's to give thanks for what we already have. I was taught by an elder many years ago that all these people chasing down life, how to make happiness in life. And he said, it's the simplest question. He said, we've been taught that thousands of years ago, that if you look at what you have and you're happy with it, that's when you're going to have a good life. The moment you look at what somebody else has that you don't, that's when you start to lose the happiness in life. Always be thankful for what you have. And as Wabanaki people, I, for one, get up every morning and I smudge and I give thanks for everything I have and welcome the sun. And this is the definition of pray in our culture. And I do the dominant culture definition sometimes and ask for the Red Sox to win, but it doesn't work well with the Bruins either. So,
Yeah. Roger, I do have one more question for you. How can people continue to support Native American heritage beyond just learning about it during Native American Heritage Month?
Oh, that's a tough one. But Autumn, the best way to do it is to think of Native American people as a people, to think of them as equals. A lot of times I think of as, if you look to the government of Canada, and if we were taking policies or making, helping to make laws or decisions based on our Canadian friend, and so they come with their own government or their own belief system and their own culture behind them. And if we tell them, you know, stop saying A at the end of everything, and don't eat that Canadian bologna anymore, and, you know, you should be more like us, you need to be more American, that would be pretty insulting to that Canadian person. And a lot of times when we go to Canada, we indulge in a lot of their things too. Like, there's most of the hockey teams are in the US now rather than Canada. And so that's honoring them by doing that. And you can call it cultural appropriation. Well, we didn't culturally appropriate teams from Canada. There's a lot of things that can cross a line. That's a whole other discussion, cultural appropriation. But to honor them like you would another government, another people. I saw the outpouring of people trying to help the Afghanis during that terrible time that the troops had to leave and their government changed. And I see a lot of people reaching out and helping them and seeing what they would need to help them to become whole again. Little things like that start from how we look at the other person and how we feel the other person is valued. And that's where it should start. Just like if down the road, somebody in your neighborhood, all of a sudden, the authorities came in and said, you can't have that vehicle. And they took their vehicle and took it away. And how is that person going to get to work? How is you as a neighbor would say, let me help you. Let me offer to take you to the places you need to go. Let me support you. Let me go to court with you and try to help support you and be a character reference over, you've done wonderful things, you've helped others, you need that card to take those kids to the things. Those are the ways that we need to look at people in our lives. Look at Indian people that way, instead of, oh, if only those Indians would be more like us. Throw that out the window. I better stop there.
Perfect. Thank you. Ryan, a couple questions for you. Are there any specific areas in Indian country or for Wabanaki people that need more awareness brought to it right now?
I think there's two big issues that I think are getting a lot of awareness, but could always use more, and it connects into, you know, another sort of general message about that. First, you know, the missing and murdered Indigenous women, girls, Two-Spirit people, and just generally violence committed against Indigenous people. I think if you look at arrests of people killed by police shootings, people that experience violence just outside of any of those contexts at all, that you'll find that Indigenous people experience much higher rates of violence. So I think that that's one thing that definitely needs a lot of attention. I think, you know, Secretary Deb Haaland, who's a Laguna Pueblo person, and she's put together a lot of initiatives, both when she was a representative and now as the Secretary of the Interior, to try and bring more light on those issues and do more to address them. But I think it can always use more light, more people knowing about it and working on it. Another area is, of course, natural resources, and that's a really broad one. And I mean everything in that from, you know, land back. So, you know, tribes getting the sovereignty back over land that's been taken away, the right to sovereignty over natural resources, waterways, fisheries, game, you know, the ability to sort of control more of the levers that deal with all our other relations other than people that have sort of been taken away from tribes. And not to generalize, and, you know, I said earlier, there's 574 federally recognized tribes. There's even more unrecognized or state recognized. So there's differences, and not every tribe is perfect. Not every, you know, Indigenous person is perfectly this way, but I think that there is more, as Roger has talked about, because of the culture, because of the language, appreciation for taking care of a lot of those natural resources. So I think that, time and time again, Indigenous peoples have been shown to be more responsible stewards, because there is that conception that these other beings, these other things that we see day to day in our lives are our relations. They are part of the broader family that we exist in, and it's not just people. And on those two things, because I see we're kind of running out of time, this might be the last question here. So the other thing I really wanted to say is, I think when Vice Chief or Roger talked about, we talk about sovereignty restoration, we talk about the language or the culture. I think a lot of times opponents of change, of the thought of Indigenous people, or more specifically in Maine, of Wabanaki people getting, this or that right recognized, or sovereignty recognized, or it positions everything as a zero-sum game, is what it does. And that's not the way that the world is, especially when it comes to looking at your neighbor. And of course, like Roger's saying, looking at Indigenous people as people. I think, if your neighbor gets a promotion at work, that doesn't mean you get demoted, right? So I think, to the extent that the tribes in Maine, or the tribes anywhere in the country, can get land restored, can get better economic development opportunities, can revitalize their language, can introduce concepts that are important to their culture into their laws and customs, can protect their vulnerable populations, can do all of those important things tribal governments want to do. It doesn't take off anyone's plate to do that. And in fact, if you look time and time again, it actually helps everyone else around them. And I think specifically in Maine, that's a theory that could be put to work, specifically with, the better the tribal communities are doing. They're in communities in Maine that might not be doing quite as well as they can. There are, the Passamaquoddy communities are in Washington County. It's not a county that has a lot of new people coming in, not a lot of new businesses. I know, from a legal perspective, there's not a ton of attorneys out there. For instance, I think Aroostook County also has some of the same problems, and they're beautiful, beautiful places, and they're awesome, great homelands. And I've met a lot of the people that live there, Indigenous and not Indigenous, and they're all great. But if we really let the tribes have some more sovereignty, some more room to run, some more room to improve the conditions for Wabanaki people, I think that what you will find is that conditions for everyone in those places will improve. And that, it is really, when we're talking about making things better for Indigenous peoples, it is a rising tide that will lift all boats, including, non-Indigenous boats. So I think that's a really important thought to take away from thinking about what's important about the language, the culture, heritage generally, really everything we've talked about today.
Great. I think the last one, real quick, how can people align with Native American heritage and incorporate it into their normal lives? What are some things that just anybody could do?
For anyone in particular, or I can go ahead and make a quick answer, and I'll have
Yes.
Ryan answer also. Quick answer: the first thing they should do is do what they're doing right now. This is something in my lifetime is only recent. It was unheard of when I was younger for anyone to ask actual Indigenous people. There were so many experts out there on Indians and books written about us that nobody thought they needed to ask. They would either, let's refer to this book that so-and-so wrote about Indians and see what Indians think. This is the first step right here, is if you want to know how Indian people think, ask Indian people. We can actually, for the better part, speak English most of the time. And so we actually need to be asked about these things. This is the first step. So everybody that's here today actually listening to this, thank you for taking that first step. You're well on your way to including Indigenous people and valuing us and our opinions. Everyone.
So wrapping up, I just wanted to let everyone know that this has been recorded, so we'll share the recording on the Pine Tree Legal YouTube channel. We'll also be sharing that link on our social media pages. And lastly, don't forget to to follow Native American social media pages as well to find out more information and to stay aligned and supportive of Native American heritage throughout the year, not just in the month of November. Thank you very much. Have a great day.